Attorney General, thank you for your brief statement, and thanks for the opportunity to ask you questions. I would just reiterate and ask for an answer to the question I raised in my opening statement. I was uncertain as to what you were conveying yesterday during your House testimony about whether you will provide a report of the report or a redacted version of the actual Mueller report.
Yes, it's my intention to provide the latter. As I said in my confirmation hearing, you know, the regulation under which we're operating did not contemplate and specifically was meant to avoid these public reports. But I feel I have the discretion in these circumstances to make the report public as long as it's consistent with the law. And as I said at my hearing, that I was going to try to be as transparent as possible. And that's what I've been working toward. There are 4 areas. I intend to release the report with redactions made in 4 areas, and they were specified in my March 29th letter. The first area is 6E material because, and I'm talking here, by the way, about the public, a report that would be available to the public generally, and then I'll talk a little bit about the report available to committees of Congress. The report I'm working on now, I would like to make available with redactions that would enable me to make it public generally, and there are 4 categories. The grand jury material, which by law must be retained within the department absent very specific circumstances, which I do not think exist here. Second category is any material identified by the intelligence community that would put at risk intelligence sources and methods. The third category is information that would impair existing prosecutions and investigations that are going forward right now, either by affecting the ability of the department to pursue them as effectively as we'd like, or being unfair to the individuals who are actually parties to that prosecution. You will recognize that Special Counsel Mueller did spin off a number of cases which continue in progress and are being handled in the department. And so we have to make sure that nothing in the report impinges on those ongoing cases. And the final category is information that implicates the privacy or reputational interests of peripheral third parties who were not charged. Now, the people who are making these redactions and implementing these 4 categories are the department working with the special counsel office lawyers, and those are the people involved in making the redactions. So, as I mentioned yesterday, we plan to identify very specifically which redactions relate to which category and try to explain why that redaction was made. I also said yesterday that when it comes to Congress, once I get this done and the public, everyone has the report, I'm willing to work with the committees. The regulation requires that, doesn't require, but it has my notification go to the Judiciary Committees, and I intend to take up with the House and the Senate Judiciary Committees, the chair and the ranking members of each, what other areas, they feel they have a need to have access to the information, and see if I can work to accommodate that. As has been correctly said here, the fact that information is classified doesn't mean that Congress can't see it. So I'm willing to work on some of these categories. The category I think is the most inflexible under the law right now is the grand jury material. But even there, once the redactions are completed, I intend to sort of read the report and see if there are areas where it affects the intelligibility or, really has an impact on the report. And I'm willing to work with the Judiciary Committees to see a workaround that could address any concerns or needs that they have.
General, under the assumption that your answer was of interest to my colleagues, I'm going to continue with another question beyond my time. I want to talk about grant funding that's been delayed due to litigation surrounding sanctuary cities. So In the past, the department has tried to enforce federal immigration law by imposing special conditions or bonus points on recipients of federal grant funding. These conditions restrict grant funding to jurisdictions that certify they're in compliance with federal law, stating that they are not sanctuary cities or states. That's not something that I'm complaining about in this question. What I'm concerned about is the money that has been held up as a result of that litigation, because of pending litigation, in regard to burn JAG grant funds. We've had success in that occurring, but unfortunately that has not been the case in the FY18 COPS hiring grants. These solicitations were pulled and applicants are still unable to apply for COPS hiring grants going back to FY18 awards. Have you reviewed the department's policies? Is there a plan to figure out how that we can provide those necessary resources to local law enforcement to retain and hire law enforcement officers?
Yes, I think this is the problem is really a function of this phenomenon of nationwide injunctions that are imposed by district court judges, and this is actually a fairly recent phenomenon. The old practice in law was that if a district court judge issued a decision, the judge could redress the grievances of the parties before the court. But now courts are granting nationwide injunctions. As a result, if a district court in Northern California, which is I think the court that may have been involved here, grants an injunction, they enjoin the grant program nationwide. Now, one of the reasons we were able to, and Lee can correct me if I'm wrong about this, but one of the reasons we were able to get out the burn JAG grants was that there had been a district court in Chicago that had enjoined it nationwide. We went to the Seventh Circuit. They required the court to reduce its injunction just to its jurisdiction. And when that happened, we were able to get out the burn JAG grants. What's happened with the COPS grants is that it's enjoined by several district court judges. We're arguing, if not today, within the next few days in the Seventh and Ninth Circuit to try to have that addressed so we can get those grants out. But frankly, I think we need to come to grips with this issue of nationwide injunctions, because I think the way the system should do these issues should percolate up through various circuit courts and so forth up to the Supreme Court, and the idea that one district court judge can kill programs nationwide is a serious problem.
Thank you for your answer. If you're successful in finding a path to see that the COPS grants are available, please be prepared as a department to proceed quickly if and when that occurs. And I don't think local law enforcement has been able to even submit a grant application. So it is significantly delayed, and maybe there's a way that those grant applications, I don't know what the injunction covers, but maybe there's a way to submit the grant application even if you can't award a grant until you receive judicial authority to do so.
I'll look into that.
Thank you. Senator Shaheen.